are number 24, I believe. Okay, perfect. So when a case comes to a prosecution, it just comes to us as the case. We don't go out and get people to say particular things one way or the other. It's just statements and facts that come to us. Does anybody have any different opinions about that aspect of it? And I know that at least one person here sat on a grand jury before. Who was that person? Yes, Mr. Well, I won't say your name, but number 29. So you've got some experience in sort of being that charging capacity in a grand jury. Tell us what your thoughts are as it relates to that concept.
Process, but to have all these pieces of evidence brought to you and being the decision making mode of helping decide whether it's enough to go to traffic. I think that still it was all brought to us, but there was a point with time where we asked for more information. And so get this information. Especially that was my experience in that, you know, I think that you.
So the what you're talking about there, where you heard some evidence that came in that was presented to witnesses, but then the grand jury got to decide, hey, we want more answers on this particular issue. And so you directed an investigation, right? Meaning that you were able to hopefully uncover additional facts that weren't presented to you. But the facts were still just what the facts were. Would you agree with that? Yeah, and the burden of proof in that particular circumstance was to get to a charging decision, correct? Remember what that burden of proof was called? Does probable cause sound familiar? Okay, so tell us what you think that means. And I apologize for putting you on the spot, but having a grand juror here is a really good somebody that can give us a perspective.
For us, in the room that we did, so this was kind of the scenario was, is there enough in front of us, evidence in front of us to actually ask a jury? Or is it so thin that it wasn't worth time? Everyone's time.
And then in your understanding, or if anybody else wants to chime in on this particular topic, please raise your hand. But in your understanding, is there a higher burden when you get further down the road into a trial process?
Yes.
Do you know what that's called? Okay, those are definitely words, yeah. Anybody else want to chime in on what the next higher burden is? And I'm going to jump back here. I'll get to you in just a second, but juror 49.
Beyond a reasonable doubt.
Okay, beyond a reasonable doubt. That's exactly where I wanted to go. So what does that phrase mean to you, ma'am, Miss juror 49?
Reasonable person. I have doubt, and the jury is reasonable. If there's any doubt that the elements are met.
How do you figure out whether something is reasonable or not?
That's what the jury. Both minds, considering all the evidence presented.
Very good. Anybody else have any thoughts on that concept? What is reasonable and what beyond a reasonable doubt means? Yes, sir. And you are number 28.
I just think that all the kind of talk and all of the detail of the circumstantial evidence isn't. How they were all the different things, so getting all that information.
So now we're talking about a different concept and I want to delve into it. Circumstantial evidence, what does that phrase or that combination of words mean to you?
It's not eyewitness, it's not eyewitness testimony for the person, not a person telling you what they saw and what they remember. It is forensic evidence, it is cell phone records, all those types of things that allow an investigator to piece together a set of circumstances and track someone through a timeline. Make sure that, yeah, we know that they were in this place at this time with these people because of these other things that are not eyewitnesses. They corroborate eyewitness or they contradict eyewitness.
So one concept that is spot on is that law says that direct evidence, so eyewitness testimony, maybe surveillance video that shows somebody stealing a candy bar, that kind of stuff is direct evidence. The law says that circumstantial evidence is just as strong as direct evidence, meaning that those other things that you can prove circumstantially that something happened is just as valid as that direct evidence. Does anybody have a problem with that concept or think that they could not follow that part of the law? Not seeing any hands. Thank you for that. So you probably noticed when we were here this morning, when we finally got these juror packets, that both sides were rifling through these things as quickly as possible, trying to decipher things that we want to talk about. And thankfully, the judge gave us some time over lunch to do that because we were able to dig into some of these questionnaires. And so some of this stuff that I'm going to do is because of that time that we got to look into it. Juror number 20. Right here, yep. So juror number 20, you mentioned in your questionnaire that you need all the facts. What do you mean by you need all the facts?
So as what the judge said earlier, like you only hear certain facts through the news outlet. I just happened to be so lucky where I didn't hear it. I was out in the country at the time. So I didn't hear anything about this till I got here. And I've heard people like say, oh, I followed it on the news. I was, this is a certain sense of this is a certain sense of that. But the issue with that is you're only following one arrow. You're only looking at one picture of the thing, but if you turn around, like say you look at this way, you see a square. Over here, you see a rectangle. When we get one plane of view, time gets cut. Get the whole picture, you get more of a broader understanding.
Okay, so I really like the way you describe that. I use Pikes Peak as an example of what you're describing. From down here in Colorado Springs, Pikes Peak looks a certain way, right? But if you go to Cripple Creek, Pikes Peak looks completely different than it does from here, but it's still the same mountain. And that's what you're talking about, right? Having that all encompassing perspective. What if you don't hear a particular fact? Are you going to be able to weigh the case based on the facts you do hear? And the facts in this case and in every criminal case will come from right up here at the witness stand. If you don't hear a particular thing, is that going to be difficult for you to get to a verdict?
Well, with my personal, with my background of my job, I kind of use decisions like this. I take one party side, another party side, and I know I'm only going to get 80% of the truth. One person's only going to figure out his 40%, the other person's going to spell their 40%. 45 to they someone win. So I have to piece the last 20% myself to figure out what happened. And then that information that I have and that information I think would happen, I have to go from there and make a just call in the situation. Whether I deem it right or wrong, it's what the facts say.
So that's a really interesting concept. So it sounds like what you're describing it when you're doing that sort of process, that last 20%, you have to fill in the gaps on your own.
Yes.
What the judge will tell you is that if you're on this jury and there's no testimony on or no piece of evidence, you don't get to fill in the gaps. You don't get to speculate as to what the facts may or may not have been on that particular point. What are your thoughts about that?
Like I said, for my job, it's what I have to do. But for this situation, I can't fill in those blanks. So I'll go on the information I have at hand and make a proper decision from that information that I received.
Okay, very good. Thank you. Juror number 2, what are your thoughts about that concept that we were just talking about can't speculate about gaps that maybe exist in a particular case and fill in the gaps on your own? What do you think about that?
I think it's human nature to try to fill in the gap on your own. But we would have to follow what the judge was saying as far as the law went and just deal with the facts that are presented. You know, and maybe we'd have an opportunity to go back and ask for additional information before we had to make the decision.
I'm going to stay up here in the jury box. Juror 11, what do you think about that?
You can't. You have to follow your evidence. Even if your evidence doesn't fit your preconceived notion of what you think it is, you have to follow the evidence. You cannot make your own determination until you have all of that evidence. And if there's a gap, well, then you can't put your ideas in there because it's what you want to put or how you feel. Feelings have no place in evidence.
Perfect. Preconceived notions, the idea that she just put out there, the preconceived notions, that's a big area of, I guess, inquiry as we get into jury selection for this case. There's already been some mention from people that have already been excused about having seen some media coverage in this case. And they may or may not have been excused because maybe they did have a preconceived notion. Again, having a chance to look at the juror questionnaires, juror 36. So back here, second from the left, you noted that you've seen some news articles in this case. And you have to speak up for the court reporter. Okay. And don't be offended when I do that. It's really for the court reporter's benefit. What are your thoughts as it relates to preconceived notions and the stuff you may or may not have seen in the media? Preconceived ideas, right? Do you think and this is for everybody, but I want to talk to you first about this, that the media gets stories 100% right?
No, and I thought about that too, you know,
What about the idea, let's use newspapers for example. Usually each newspaper article has a word limit, so they can only fit so much stuff in before they get to the end of their story. In a case like this, do you think that they can fit all of the facts in a particular news article to tell the story? Probably not, right? So with that in mind, based on you've already said that you've seen some media, can you set that aside? And if you end up on this jury, only listen to the facts that come from this witness stand and then render a verdict based on what you hear from this witness stand as opposed to the outside noise of the media? You believe you could? Okay. Juror number 44, you also indicated that you had seen some media here in the second row. What are your thoughts about what I just talked about? Do you think based on what you know today, have you heard any facts in this case? Because it hasn't come from the witness stand, right? If the judge said, you know what, we're done, you got to give us a verdict right this second, what would your verdict have to be? Not guilty. Yeah, exactly, not guilty. Can you set aside what you've heard in the media and just listen to what happens from this witness stand and those facts and then make up a verdict based on that information? Okay. What about juror 49, jumping back here? Yes, ma'am.
can I set media information?
Okay, that's very definitive. Why do you say it so definitive?
Talked about, judge told us several times, the only fact So. So white line, fine.
Kind of like Men in Black, they flash that light and then your memory's gone. No, we don't. And again, that was juror number 28. Does anybody that has seen the media, and if I could just see a show of hands, I'm not going to call on every particular person, but a lot of people indicated they'd seen some media. Any of you think that you would have difficulty setting aside what you've heard in the media and just listen to the facts that come in from the witness stand? And we're going back to juror number 70.
Say that. I had any questions.
You bring up an interesting point, and that is that jurors that sit on criminal cases in Colorado, let me back up. When we put a witness on the stand and it's a prosecution witness, one of us will do a direct examination, and then defense will get to do a cross-examination, and then we'll come back and do a redirect examination, and then we're done. Whoever sits on the jury, sitting up in this box, gets to write down their own questions and pass them to the bailiff, and then the judge will ask the question. If it's an admissible question, we'll ask the question of the juror or of the witness, so that jurors get to be a participant in the questioning of witnesses in case there are, just as you described, any questions in your mind. It's a really valuable tool for jurors to understand and ask questions in their own way. And oftentimes they ask better questions than we do because they're coming at it with more of an open mind to the case, and they don't have the preconceived notions that we do from one side or the other. Anybody else that had media exposure to this case think anything that you want me to know about right now as it relates to media, or that you would have difficulty setting aside that media exposure to this case? Not seeing any hands. Does that mean everybody that has seen the media can set that aside and be fair and impartial? And ma'am, you're right, you're nodding your head and you're juror 34.
You know, I kind of, that's a person who's kind of been on, both sides of this thing, kind of the accused, kind of, I've seen, how media twist things. So I kind of hold that with a grain of salt personally. I know that, I can be advised, because like I said, I've seen that and I've seen how they, work. And like, wait a minute, that's not what happened. Like I said, I've seen how they person. It kind of makes me danger and that.
And so, and you're one that had, I think, marked down that you had seen some media, right?
Yeah,
You,
I've seen media, yeah.
yeah, and you can set aside your exposure to that media. Okay, okay, perfect. Let's see. Juror number 57. Yes, there you are. What are your thoughts about sitting on this length of a jury trial? You talked about a little bit earlier about with the judge. You'd expressed, even on your questionnaire, some real reservations about that. What's your thoughts? Okay, freaks you out. Why is that? If you end up on this jury and you're dealing with that stress where you're pulled away from your job, affecting, I think it's D11, right? Affecting D11 school district, are you going to be so focused on that concern that it'll be hard for you to sit and listen to the evidence in this case? Okay. So you have to tell us whether you think you can do that or not. We can't jump in your head and make that call for you, right? So what are your thoughts about that? You don't think you can? Okay. Let's talk about the concept of difficulty sitting in judgment of another person. Occasionally, we get people that come into this process and say they cannot sit in judgment of another person because they can't know every single fact about a particular circumstance. Does anybody in this room feel that way? Yes, ma'am, and you are
15.
15 again, thank you.
I kind of going back and forth on that because I know my personality. And I don't see just black and I don't see just white. Usually I can see both sides. And I feel a little confused about that on I have a little bit of fear about if I'm not completely sure how to pass judgment or pass sentence, how I'm going to feel if, let's say, I'm the only one that's thinking not to go along with everybody else, how that's going to feel. I mean, I'm a little nervous about the whole thing, actually.
Okay. So tell me if this calms your nerves a little bit or does it really help? Every single day we hear stories from two different people and yet we can figure out kind of what happened. Do you have trouble in those situations, trying to figure out which one is more accurate?
Well, like I said, most of the time I can see both sides.
Sure, yeah.
You know, like a situation like that, like, you know, when my kids were growing up, there was always, you know, a conflict here. One would say one thing, one would say the other, and I would try to resolve it that way unless I can know for a fact that maybe one's lying and this one's being completely honest, you know?
Sure.
I don't know how else to answer it.
Okay. I think the way you're answering is the way you should answer it, which is what's in your mind and what your thoughts are on it. Have you ever had a situation where maybe you hear two people that went to the same wedding and they describe it almost like they were at two different weddings?
Yeah, we don't.
Does that mean the wedding didn't happen?
No.
Okay. So do you see what I'm saying? That even in normal day life, we hear stories and we're still able to figure out that something happened and figure out what that something was. You agree with that?
Yeah.
Okay. Anybody have any input or thoughts about that idea? About hearing different people talk about concepts or stories or events and maybe having conflicting recollections of that event and yet still being able to decide one thing happened? Anybody have any concepts or thoughts about that? Juror 35, what are you thinking about when we're talking about these different ideas? Yes, ma'am, that's you. What's going through your mind when we're talking about just basically, I'm doing like a status check. All the things we've talked about so far, including that last topic, what's in your mind? What do you think about those different ideas? Nothing right now? You're half asleep? Okay. My wife tells me I'm boring like that too, so. Will it be hard for you to sit for basically a full day each day to listen to witnesses?
Like today, yeah.
Why, what about today?
Haven't start this thing and I think.
Okay, okay.
Mr. Allen,
Yes.
you have a question.
Oh, yes, sir. And you are juror number 26, I believe.
Yeah, I would just say that, all individuals, all these people. And we have, different experiences, whether it be education. We're gonna interpret things differently. Really that kind of what the differences are, we can kind of overcome that with this kind of say.
Okay. So what you're describing is sort of that deliberative process that whoever's on this jury is going to go through and we get to the end, where you come together after all of the evidence has been presented and you're back in the jury deliberation room and you're talking about the different aspects of what had happened. Does anybody think it'll be hard to remember all of the details in a trial that is this long? And you've got your hand up in the back here. I believe you are number 66. 59, you're right. Part of that is that, I'll get to you in just a second, sir. Part of that is that we all learn differently too, right? Some of us can be visual learners, some of us have to read things. Some of us has to hear something over and over before it really starts to sink in. That's the cool thing about jury service is that it's the collective mindset. So all 12 of the jurors that are deliberating on this case work together to figure out how the evidence fits together, how those pieces fit together. And one thing, I don't know if the judges talked about it, but you'll all get notebooks and you can write notes as the witnesses are testifying. I think it's really important when you're thinking about if you end up on this jury to take notes because of the length of the trial. Not Mr. 66, I believe. So do you think that, even though I just described the way that a jury works together, do you think that would help with that process, or do you think it would help? Okay. So do you feel comfortable, in your situation to being able to, hear all the facts, consider those facts, and then work with others to come up with a verdict? You do the best you can. Okay. And number 70 again?
I feel like I need to like. I think that's what I learned. What was explained that.
And are you referring, oh, go ahead.
Oh, and I'm also referring to the fact that if you talk about, the fact that they to and it's. There's no problem. That is- Why would be remiss if I didn't say.
So when you, let's assume that you get on the jury and you get to the very end of this case and then the judge reads the law to you. The judge will read out the instruction as it relates to not guilty by reason of insanity and other aspects as it relates to that particular defense. Do you think you could set aside potentially what you learned from psychology? You do.
Basically, it's like. That's, he's telling. Great. What is definition? Same. This is what he.
Okay. So I'm glad, Well, I'm glad you brought that topic up because that's a central part of this discussion as well. And that is the mental health aspect as it relates to a plea of not guilty by reason of insanity. Yes, sir, Mr. 28 again. And I don't mean that in a bad way when I say again.
Seems like this kind of defense, which isn't even allowed in all states. Because throwing head on this, it seems to me that defense isn't necessarily saying that defendant didn't do it, saying they did do it, however, they weren't in control of their faculties at the time. Reason why they didn't do it, you can't hold them responsible the same way that you would hold someone responsible who had their full head. So the evidence that we're looking at, like, why is there the same level of preponderance of evidence if everyone on that side are agreeing that the person did it from an evidentiary standpoint? Now we're arguing over whether they should be held responsible because of the way their mind was working at the time that the crime was committed.
Okay. So let's think about, remove ourselves from, as it relates to this case, and look at a different type of case that also had a lot of attention. And that would be the Aurora theater shooter case. Does everybody know what case?
Oh, this is appropriate all reference that is.
Council approach, please. Mr. Allen?
Thank you, Justin. So if you think about hearing something bad happening that is shocking when you hear about it, is it natural as people to think there must be something wrong with that person that did that bad thing? No, who said no? I heard a no. Okay, and you are 36? Yeah, you're good. You're doing great. You're 70.
From my perspective, you can throw that in. On just what you see. Because the name.
That's exactly right. Who has the burden of proof in this case? I do, right? The DA's office sitting at this table has the burden of proof. What things do we have to prove? Anybody know? You don't really know because you haven't had the instructions yet from the judge, right? The judge hasn't told you this is the recipe for whatever the crime might be. So the judge used the idea of a Denver omelet and throwing some ingredients in there and saying you might have a tasty omelet, but it's not a Denver omelet. Who thinks that one of the ingredients to prove a crime in the state of Colorado is that we have to prove motive? Juror 11.
You have to prove that they had an intent to commit the crime in order to receive something of benefit, whether it be that they received something, removed somebody from their life, removed, like in case of arson, a home or like a bill from their life. You have to prove that they had a motive to do this with the intent to change something.
Okay. Who else have their hand up? Yes, sir. Juror number 24, I believe.
I think for the overwhelming majority of cases, there is one aspect, however, there are instances of crimes which they
Okay. Okay. All right. Other people that haven't spoken, juror 7. I was gonna get to you eventually, but you're sort of on an island. Yeah. What are your thoughts about motive? We've heard two different viewpoints now.
I think every crime is.
All right. What about juror 9? What do you think? You thought you were on an island too, didn't you?
Yeah, I don't think.
Okay. So would it shocking of you to hear me say that in the state of Colorado, ingredients to prove a crime, motive ain't in that ingredient list, don't have to prove motive. Juror 47? Yes? You had a interested, curious look on your face. Okay. What went through your mind when you heard that?
I guess it's not shocking, I agree with her.
Okay. All right. What about juror 45? Okay. Juror 61. Let's assume that you end up on this jury and you hear lots of evidence, but you hear zero evidence about motive. You think you can still render a verdict? Okay. What about juror 69, way back there? What do you think about this idea of don't have to prove motive? There doesn't have to be a motive ingredient. No, it does. Again, this is a safe space. We get to talk about these concepts as we're hearing some of these things. We probably have never in a group like this considered them with this many people together, right? So these are all very fair and safe things to talk about. Juror 28.
I would have to class crimes, difference between water and first degree murder.
So getting into,
Penalties are a lot worse for first degree murder because it's premeditated, whereas someone who accidentally killed someone, even if penalties are less. They didn't think it through.
okay, so let's talk about that.
2 minutes, Mr. Allen.
Thank you, Judge. I was just gonna ask. Premeditation, you mentioned premeditation. That means that somebody planned to do something. But even in premeditation, there's no evidence that's presented on motive, why they did something.
That's, you can't, it's like someone was mentioning, you can't prove why. That's evidence that points to a why. That helps investigators decide who they're gonna try to investigate more strenuously. Can't prove why.
Okay.
So how can you use that as a way to fix them?
Do you feel like if you end up on the jury, you could be okay not hearing the why and still getting to it? Okay. Coming back to juror 11, after this discussion on the motive part of it. What are your thoughts now?
That I can see that there have been times where maybe there wasn't a clear cut intended motive, and that, especially when you're looking at mental health, there may not always be a why.
Thank you. Is there anything that, for any of you, that is gnawing at you? I wish Michael would have asked this particular question because it's really important I get this out. Anything like that that we should hear about now before I sit down and stop badgering you with questions? And I apologize, I didn't get to hit everybody, tried to get as many as we could. Any last thoughts, last ideas, things that you think would be important for us to know about you? All right, thank you.
Thank you. I wanted to do a little bit of follow-up with juror number 9. I was looking at your questionnaire and you said that you had physics class and I saw that you had it on Tuesday and then there was a TR something, but I didn't know what that meant.
So Tuesday, Thursday, but my Tuesday class is my Thursday one is long, but this Thursday night, I know one, so I have the lab involved. Already thought about it, and I could. But I also do work full time, but.
Well, I was gonna ask, how are you gonna, because you didn't really raise that much. And so, and I had a lot of other students that were in here. So I was trying to figure out how you're gonna still make your physics class. When does it end?
Family,
Okay,
I'm graduating from bachelor's from teacher. Well, I thought about discussing with the teacher, well, he does his lecture on. I have access to those PowerPoints, but I do class, so, I mean,
okay, well, if you're still here at the end of the day, here's one of the things that I want you to do. I want you to talk with your teacher, find out whether or not there's something that can be worked around, whether or not it can be accommodated, okay? Because if you're still here at the end of the day, you're gonna come back in 2 weeks. And one of the things that I'll ask you is, what's the answer to that question? And then juror 45 over here. Tell me about your horse farm.
on the questionnaire.
Okay. Okay. Well, I wanted to talk with you a little bit about that because you hadn't mentioned it. And I have had people in here serve as jurors that came from a ranching or a farming occupation, I suppose. And they have very early mornings, as you know. And we had one gentleman who he made sure, he said, you know, I can do this. I'll get up, I'll feed the horses before I go. I'll feed them when I get home and it'll all be okay. It'll just be a long day. So you think it's going to be okay? Okay. All right. And Councilor Froch, please. All right. Mr. Tellini.
Woo! I hate this part of the trial. Not this part, all the time before where I can't talk. This part I like. This part I like. I want to start off by thanking each and every one of you. We let you all go to lunch and you all came back. You came back knowing that you could end up having to be with us for the next 8 weeks. And that actually talks a lot about each of you. And it talks about our community. They do statistics in each different county and jurisdiction about the number of jurors that actually shows up in the summons. And El Paso County is always 1 or 2. Because our community here cares a lot about their civic duty. And I want to thank each and every one of you for doing it. Because I know each and every one of you has someplace else you would rather be. And I know, as I think we heard juror number 45, talk. She heard all these other people's reasons why they can and said, you know what, this is going to be inconvenience and I can do. And I think there's a lot of people here who were in that kind of position, juror number 28, who I'm going to get used to this number thing, but a lot of us, we want to do this because we know it's our duty. And I worry sometimes we want to give the answers that indicate that we can give through our duty. And what I want to emphasize more than anything right now, you guys only have one duty, and that's to tell the truth. Okay? Answer as honestly as you can and not try to give me the answers that I want to hear, not the answers you think they want to hear, or not even the answer you think the judge wants to hear, but to give us the honest answers so everybody can make decisions based upon that. Now, they call this jury selection. I think that's a little bit of a misnomer. What it should really be called is juror deselection. I don't get to pick anybody. Mr. Allen doesn't get to pick anybody. We're going to go through this process the next 2 weeks. And hopefully we come Monday, April 3rd, we'll have another group. We'll get rid of some more of them. And then we'll have the people who are going to be here with us for the next 6 weeks. It's kind of like Survivor, that game show. But instead of like a cool prize, you get stuck here. Now, the good thing for a lot of you guys haven't even made the island, okay? This is the casting part. This is he who's going to get to move on to Survivor Island next April 3rd. And the other thing I want to know, you all to know, we know how hard it will be on everybody. We also know that because of some factors I'm going to talk about, it's not going to be easy. That's very easy getting the truth in this case for a lot of different reasons I'm going to talk about. And we're ready for that. That's why we've got 2 weeks of this to go through. And again, that's why it's important just for you guys to give the honest answers so that Ms. Stauch gets a fair trial, which is what we're all here for. Can everybody agree? I'm just going to give the truth. I don't care what anybody says. Okay, don't worry about being offensive. Don't worry about being politically incorrect. Don't worry about being selfish. Don't worry about hurting my feelings. I have none. And so when we talk about, I kind of like to look at this kind of almost like a job interview for the people that I'm going to get to be surrounded with for the next couple of months. And the first thing that I want to talk about, and the judges talked about it, Mr. Allen's talked about it, it's hardship. And we're mean, we drag people on the street, we make them come here, but we don't want to make somebody homeless. We don't want to make somebody miss a vacation they've had planned for a long time. We don't want to make kids flunk out of school that they've been working, hard for. It's inconvenient, but sometimes this gets to the area that it's not fair. And that's just general applies to every juror. I also have some selfish concerns because my only concern is that woman right there. Okay, I like everybody. I want everybody to be happy, but my obligation is to her. And so I also worry, this 45. I'm not saying this to you, but just as an example, that people have stuff going on in their lives that maybe it doesn't rise to the level of what the judge thinks of a hardship, and maybe we can make you come with us for the next 8 weeks, but I can't have you there paying attention. Even if I make you come and sit here, your mind's going to be somewhere else, and that you can't focus on the evidence before you. And so when I'm asking some of these questions about hardship, that's kind of what I'm going to.
And then don't, I thought I read in your questionnaire that your husband has some disabilities as well.
So, he's not disabled. But stuff.
Okay. Oh, okay.
He takes care of himself.
Oh, okay. Okay. And if we make you be here for the next week, 8 weeks, are you gonna be worried about your horses or are you gonna be able to pay attention?
Well, no, I'd be able to pitch it out.
Okay.
Back and get them fed.
Okay. You're number 15.
Yes,
I noticed that, I think you're talking before, you indicated you got to take care of your grandchildren.
yes, I take care of them now. I go up to Centennial either Sunday night or early Monday morning, and I stay with them Monday and Tuesday, and then I come home on Wednesday.
Okay.
My daughter does not have anyone else to watch them, and if she had to hire a nanny or someone to come in, that would be like $300 extra a week for her. And when I text her at lunch and told her I was still here and what might happen, and she just sent me a capital 4-letter word.
And so. I bet I can guess the word of it.
She had to take them to work with her today.
Yeah.
And she's a sales rep for liquor. So
Yeah.
she had to drag them into the liquor stores.
Okay. And so what it sounds like, while this might not necessarily be a direct hardship to you, it would be a gigantic hardship.
I mean, if
to
it
your
wasn't for that, I would
Huh.
be glad to, do the service, so. But I don't want to put that hardship on her and my son-in-law either.
And you're number 59? Yeah, you have a kid that you have to transport to school, correct? What time do they get it out? And if we make you be here for the next week, who's gonna pick them up? Okay, you gotta tell me how big of a, cause look, I mean, if this was my guess, like a 3-day trial, it'd be easy for you to say, hey, this is no problem, I can do. We're talking about, you're gonna have a couple weeks off, but then 6 to 8 weeks with us. How hard is that gonna be for you?
If I absolutely had to, I would figure it out.
Okay.
But if I have to,
And you're number 65? Yeah, and and how old are your kids? Oh. Okay, well, and I guess kind of, who's taking care of them right now?
yeah, so kind of goes into like a little bit history, which maybe is good to bring up. I have a history in teaching, and it's that. So I feel like that should just be known. But right now my husband he works at UC Health with heart surgery, so he's kind of all when there are no cases. He's sometimes called. My in-laws do live in town. I'm also literally tomorrow interviewing position to start next fall. So figuring out.
Yeah.
Okay, and how, did you say your child was 21 months? Okay, go ahead.
And is it going to be a situation, if you're here for the next week, 8 weeks, so that a lot of times your mind's wandering back to how your son's doing?
I mean, I feel like.
Yeah. Either way you answer this question, it's gonna look bad for you.
I think especially where I'm at now with, where I'm at now with him and.
Okay. Juror number, is that 66? And again, I just want to hit back on this memory. Like you said, you have short-term memory issues?
Tell if my memory's not what it used to be.
Okay.
My
myself focusing every day on a little more on what day of the week is it, and if I got anything important going on, it doesn't come naturally.
Yeah. Well, I mean, you know,
Some, not a lot, but some.
and we're gonna get a lot of information, you know, when in the 6 to 8 weeks that you've got to kind of keep and store. You can take some notes, but otherwise, you know, she has a right to 12 jurors, not, you know, 11 and a half. And I'm not saying that, you know, badly. No, and I appreciate you doing. You know, I could try to dunk a basketball all day long, but it's just not going to happen. I mean, would you say you have some significant concerns about being able to remember everything over a 6 to 8 week trial? Okay. Juror number 47? Oh, right. I'm sorry. You put on your questionnaire that you're supposed to be out of town on the 22nd, April 21st and 24th?
Yes. The paper to this Wednesday,
Okay,
I'm actually moving up to Denver for a job on the
okay. So then you wouldn't be able to be here with us.
correct. The 20. Oh, I will be unavailable.
Okay. Well, that answers that question. All right, now, kind of get over, you know, first part, the hardships, and those are pretty easy. Initially, when everybody asks, you know, the jurors, they ask, you know, do you think you can be fair? This 34? What does that mean?
Because both sides. Fair, just your, you know, style.
Yeah.
You don't make sense.
Juror number 44? What does that mean to you? Yeah.
Gotta look for both sides of the story.
Now, if this was a civil case and just about money, Mr. Allen rear ends me and we're trying to determine who's at fault and where the money goes. That's all really that we ask of jurors is come in, kind of have everybody be even, fair, and do the best that we can. In a criminal case, it's a little bit different than this 43. In a criminal case, you come in with a presumption of innocence. Okay, so not coming in, everything's equal. I'm coming in here thinking she didn't do this or she's innocent for whatever reason that she's innocent. And it's kind of different than what we normally do in life, correct, Ms. 43? For example, I've got 12 and 14-year-old boys. And when they were younger, you know, 4 or 5 years ago, they'd be out playing in a different room. And I'd hear the younger one start crying. When I was coming back in that room, I wasn't presuming the older one innocent. I was wondering what you do to your brother. Okay, it's a little bit different concept. Would you agree with that?
Yeah.
And it's not how we normally do our day-to-day life. Is it 56?
Yes.
What does that mean to you, the presumption of innocence?
Other than,
Would say that again?
I would say she's
Yeah.
admitted she's done it, but there's mitigating circumstances to do it.
Well, and I want to get something clear here, and just so everybody that that's not saying that. It's the burden to prove beyond a reasonable doubt for what you know, charges. And then I guess the easiest way to think of insanity would be something similar to an affirmative defense. For example, I'm charged with assaulting Mr. Cook or with punching him. Okay, they would have to prove that I actually punched him. A defense may be, though, that I did it in self-defense, that he said he was going to punch me, and so I did it. And so that made it clear, they still have to prove it. And then then as well, though, after that, then you have to consider whether or not she was insane at the time.
Because the fact is you're both are saying to punch out.
Yes,
That's what I'm saying. The fact
Okay.
is, it's happened.
yes,
No one's disputing the fact that it happened.
okay.
Dispute is whether it was a mitigating circumstance to that.
Whether,
The reason for it.
and then you'd have to presume that if it's not guilty by reason of insanity, that she was insane, and they're going to have to prove, they have to prove that she was sane. Okay, it's not our burden to do that. Okay, juror number 54, what do you think about that?
Presumption of innocence.
Yep.
Foundation. Part it. I guess we've got a lot of information. Start with that.
Okay. Well, and it's interesting, you say we have to start with that. When the judge read that instruction, a lot of people miss out. They think the presumption of innocence just is at the beginning of the case. Presumption of innocence actually goes through the entire case. Up until all the evidence is done, up until they get to argue, we get to argue, they unfairly get to argue again. And then it goes back to you guys. Until you get back in that jury room, you have to maintain believing that she is innocent. Can you do that, number 54? Now, I think one of the reasons why we have so many people, it's kind of a counterintuitive thought process, Mr. Number 2. I think it's even harder, or the thought process is harder, when you have a case that's had a lot of media exposure. I guarantee you, everybody at that table, and even that gentleman right there, which there had been no media exposure in this case because it make picking a juror alive. Sure. What I worry about is when people have read stuff on the news, seen stuff on the news, that this concept of presumption of innocence is more difficult. And it's not, to me, it's more than just like, I'm gonna try to put it aside and not, think about it while the only evidence is coming in and whether or not they've done the evidence. But for me, it's difficult. Can you, even though you've been exposed to stuff in the news, breathe life into that concept of presumption of innocence and believe her innocence up until this case is done?
Sure, because that's what she's entitled to under our system. Absolutely.
Ms. 11?
Yes,
Yeah, do you see why it scares me? Why I'm nervous?
yeah.
And I'm nervous that everyone just wants to tell me, that answer that I can do it. But it seemed, how much news have you seen on this case?
I live in Fountain. When it first happened, a lot, because we were looking for this kid.
Yeah.
Since they found Gannon, I kind of went, okay, at least know where he's at. He's not out missing somewhere.
So when you say we were out, like this is out and people that are actually looking around.
Even if you went to, the Safeway, Fountain's kind of small, you went to the Safeway, every little dark cardboard. Look,
Yeah.
see if maybe he's been picked up by somebody. Then when he was found, it was like, well, there's gonna be judgment at some point. And there was no point in following it any further than that. My concern was that there wasn't a little boy missing out there somewhere in the woods or wherever.
Were you angry?
When I found out he had been found.
Yeah.
As any parent would be.
I was a parent with me and that had been deceitful and everybody was out looking for him and they'd been dead. And everybody, not only are you angry about a child being dead, but you felt like, I'm not sure a lot of people felt like they've been kind of duped.
Yeah, a little bit.
Yeah.
But
You're actually part of the Facebook group.
I was part of a Facebook group that was Find Gannon, for people who live in the Fountain area. Hey, I just saw a kiddo here. Has anybody seen him? And since he's been found, that group is gone pretty much silent, other than they do give updates of court appearance here, court appearance there, if anybody's following it, but I don't really do a lot on Facebook. Well, my job, I go on there, search when you search and I stand at that.
And I want to talk briefly and easier, but, your job, so you work for DHS
Yes.
and you investigate people who are
Community welfare fraud.
doing welfare fraud, and then you take that evidence and you present that to the attorney and they choose whether or not to file charges.
The short of it, yes.
Yeah.
A lot of it is, there are times where it's not a high amount, wasn't a high motive of intent.
Yeah.
Those we deal with in-house, either through the Office of Administrative Courts in Denver, or we even have a waiver process where they can sign, I screwed up, I'll pay it back.
Okay.
When I have high amount of dollars or high amount of intent, meaning they made trying to commit welfare fraud their full-time job, those I do refer to the district attorney, at the district attorney's office to then file criminal theft charges.
I mean, so at least, I mean, in part, you're a criminal investigator.
Yes.
How did, Mr. Seven? Have you had any media exposure?
No, actually. I haven't.
Being in Iraq?
No, I've been to work all the
Okay.
time and then come home and. So I go to sleep at like 9.
Juror number 20?
No, I got no media coverage. I was currently overseas at the time.
Okay. Number 21, I noticed that on your questionnaire that based upon the media coverage, you're going to find it hard to be impartial.
I don't follow mainstream media.
Yeah. Okay.
Stories. So I don't mainstream media. So. Things have been presented. It's like, oh yeah, I really did know. As far as like.
Okay. 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 And I guess even more so than setting aside though, but presuming during the entire trial that she's innocent, how hard is that when you're coming in with some preconceived biases? Okay. No, and that's all I asked.
It would be difficult. I would hope that if I was in the position.
Yeah.
People ask me about certain things, I'm like, you don't. You know, you really don't. You can know what you hope.
Yeah.
Right, you don't actually. Trying to. Laws and the system.
And if I'm mishearing you, absolutely tell me. What I'm kind of hearing from you is you understand the importance of this presumption of innocence. You want to do this, but in a case where somebody is accused of brutally murdering an 11-year-old kid, and that you've heard about that before, you've got some serious doubts about your ability to be able to do that throughout the trial.
The teacher. Not resulting in this.
Yeah. Yeah, absolutely.
We really don't.
No,
It's just.
no, and thank you, Ms. Sloan. I mean, this case isn't for everybody. And the only thing that we're asking right now is for people to let us know. I guarantee if I was like in your spot and I was answering all like the questions from this table, I wouldn't be a good person to be on any criminal case because I have beliefs that cannot be overcome in regards to certain things. Civil case, I'd probably be fine, but I have core values that sometimes we can't ask people to set aside core values. And that's kind of what I'm getting at here. You know, we have, you know, somebody who's accused of a horrible crime, breathing presumption of innocence into a case like that. Sometimes people have core values that they just can't do it. They can do it like on a theft case, or they could do it on a drug case. Juror number 24. What do you feel about that? That sometimes people have just the core values in certain cases that they can't do, that they understand, like, I've got to presume this person innocent during the course of this trial. And if this was about stealing a candy bar, I can do that. It's about brutally murdering an 11-year-old kid, I can't. I'm asking you. Okay. Number 26?
I can as well. I'd like to believe that, self in that position when you were judging somebody and say, hey, am I being fair to that person when I stand the facts? Not using any bias or anything. Want to be as honest as I can.
And Ms. 34, you follow some in the news, correct? And it is kind of the same thing. I mean, yeah, my worry, people, yeah, said, I just, maybe I'm wrong, but I feel that it's easier for people who know nothing about the case, having to go, well, presumptive innocence, I can do that. But you're paying it, I watch it on the news, I make an opinion on it every
Right,
time I watch.
absolutely. I think that, and I think if you ask me to do that, sure. I think, after I said, let's go through it. But I wasn't as aware of it, these.
Yeah.
Told from a certain perspective, that they really have, audience to gain. Kind of made me go, wait a minute, you know what I mean?
Yeah.
So, yeah, I think that, it very much changed.
Mr. 39, what do you think about that? And just let me know, are you saying as you sit there right now, when you're talking about a horrific murder of an 11-year-old kid, you've got some concerns about being able to breathe life and presumption of innocence during the whole case? All right. Ms. 43, are you more with Mr. 39 or Ms. 34?
I'm actually sitting here thinking.
Okay. Okay. Mr. 44? Can you breathe the presumption of innocence when the accusations are the horrific murder of an 11-year-old kid? All right, Ms. 45? And Mr. 44, you heard anything about this case on the news?
Just pretty bad.
Okay. Ms. 62? What do you think about this? Can you, when this charge of horrific murder of an 11-year-old innocent kid, can you breathe life in the presumption of innocence? Okay. Yep. I'm just asking, as you sit there right now, whether, I'm not asking if you can try, do you have serious reservations about your ability to do it? Thank you. Mr. 61? All right. Ms. 59, do you have any reservations about your ability to breathe life into the presumption of innocence when we're talking about the horrific murder of an 11-year-old kid? Well, and that's one of the things the whole transition to. I think a lot of times with lawyers, we forget what kind of some stuff has. You're going to have to, in this case, you're chosen to be one of the people insured. Look at autopsy photos of a dead 11-year-old kid, been decomposing for a while. And you got to look at those photos to determine that because there's evidentiary value that be important. And some people do it, and some people just the thought of it is getting emotional and they can't do it, no matter how much I ask them. Like, I can't dunk a basketball. Some people, I can't look at that and be rational about it. And I know Ms. 65, I see you getting emotional. Oh, maybe not. I'm far back, so.
Because I've been thinking about that.
I would like to think this is like a. Discrepancy anyway, so like, and as some people were saying some things earlier, it's like, well, yeah, like I'm a parent too, but, and this, I know. Um. There were previous questions.
Breathing life into the presumption, the breathing life into the concept is, it's a due process right. Everybody in this country is accused of a crime, has that right, no matter what they've been accused of. And that's why we're taking, we know that it may be hard in a case like this for some jurors to do so. That's why we're taking the time. And only you can answer these questions, like, again, I do stupid sports analogies, that's all I'm good at. You know, if somebody's saying, hey, can you dunk a basketball? There's no way I can do it. Can I hit a 3-point shot? Once out of maybe 2 out of every 10 tries, okay? There's like a layup, boom, I'm gonna get that 90%, you know, the time. I'm just trying to gauge where people are.
Yeah, no, I think. And I don't think. Let's have like the stomachs for this, but
Yeah.
I think. That's kind of. Would I be able to?
It's not gonna be fun.
Right.
Miss 74? What do you think about that? Some of the evidence, I mean, you're gonna have to see autopsy photos that are gruesome. Gonna have to be able to look at them to see what those autopsy photos are trying to tell you. How confident do you think you can, because again, that presumptive innocence goes all the way through trial. Breathe that in. Breathe into that concept even after seeing those photos. Can you do that from this guy? Number 69? Number 49.
Yes. If I have a job to do.
That's as he said. Yeah. I see you raise your hand, 24.
Yes, I think that the severity of the situation.
The 70?
Say.
Yeah.
It's closer.
Yeah.
But that instead of going to be lost soul.
Yeah. No, absolutely. And I guess the way that I would rephrase this, I'm doing this kind of almost like a job interview. I've done a lot of cases. I've had cases where jurors said, I have to look at autopsy photos. No, I'm not doing it. You know, you can make me sit here, but you can't make me look. You can't make me do that type of thing. And there's a lot of people like that. And so I'm trying to get a sense. One, I want everybody to know what this job is going to be. And then, you know, to see who's going to be best to have that job. Does that make sense?
I guess my other question to you is it doesn't, you know, so if what you're asking is whether or not I will be able to be legally. Like,
No.
then we'll tell you.
Yeah.
Okay. But the question is whether I can presume. See enough.
and based on the instructions.
That's what I'm asking, like, it is, you know, is looking at those photos going to be so emotional that you're no longer able to do that job, I guess. That's what I'm just inquiring.
I don't think so.
Okay.
But I'm just saying, if I sat here and I was like, you know, I
If,
don't know that I can maintain an expressionless
no
poker
one,
face. Doing, I mean, throughout, could I do that for 8 weeks?
no,
Ability.
no, and I just want to be clear, I'm not asking that. No one's asking that. And if you're telling me you could do that, I know that you've already messed up rule number 1, which was to be honest. There's going to be emotion in the next 8 weeks of this whole thing. The question is, can you have those emotions come up and set them aside and still presumption of innocence, hold them to their burden, you know, look at all these facts like that? Or, you know, is this going to be something that I have concerns as I am right now? I can feel the emotion coming up that I'm not going to be able to do that. That's kind of what I'm trying to get at. Does that make sense, Mr. 29?
But you asked.
All right.
I think the scenario, I almost don't get the scenario you're thinking. Okay? So you're expecting, right, I actually see a jury starting and saying, yes, this defendant is it. But we have both sides of the table presenting evidence, trying to convince us that one way or another, you're going to be giving us evidence, trying to convince us of a certain thing. So to sit there and say that until after 8 weeks, at the end of 8 weeks, when I walk into a jury room, that's when I can start forming opinions. And even imagine that. Because I would be sitting in that jury box, and every piece of evidence that comes apart has to be playing into my opinion building. That means I no longer think she, defending is innocent. I don't think so, but
It's a little confusing. And the law, like I said, what the law requires is for you to presume your innocence, and that presumption of innocence, according to the instruction you're gonna get from the court, maintains throughout the trial, all the evidence up till they're done talking and I'm done talking. And I guess one way I've analogized it is, do you like James Bond? You've seen James Bond movies?
oh yeah, I've seen some, I guess, yeah.
Okay, and you go see a James Bond movie and you're watching all the movie, and no matter what happens to James Bond, I think he's getting out. I mean, he's tied up like this, he's got a laser coming up right there for him, he's telling him all his evil plans. But I'm presuming that James Bond is somehow going to get out. I'm not ignoring the situation, but that's how I think this movie is going to end. And if that laser came up and cut James Bond in half, I would be shocked. But that's, I guess, the nearest analogy, that something's going to happen that you presume that she's going to be the innocent until this case is done, and you go back and you can look at everything all at once. And it's not saying that you don't make opinions while it's going, but it's at the end of every day, say, these are all the stuff I've learned, and when I come here and you're said every day, I'm going to presume I'm going to find you're not guilty until the end. But you don't ignore all the stuff that they're doing every day. But every day we got to put on a presumption of innocence hat, come in and go, one of my jobs today is I presume her innocent. You're going to come in, you're going to have opinions, but put that back hat on every day. Does that make a little more sense?
Yeah, a little bit more, yeah. I'm like, I was gonna go to the jury room.
No.
Flip a switch, because now you get.
No, we want you thinking the whole time. We want you thinking the whole time, but it's just, we want you thinking from the perspective that you believe that she's innocent, and they've got to change her mind. You know, that I guess that's the easiest thing, you know? Everybody has their different politics, you know, and you go into one thing and you think, I'm never going, I disagree with you and everything like that, and people try, you know, to change your mind. It's your politics up until the end of this thing, or she's not guilty. And they're going to be trying to change your mind, and everything they say, you put in there and you think about it and you form opinions, but still every day you got to come back and presume innocence. Can you do that, number 29? Okay. All right. Anyone else? You know, I don't have a lot of trying to pop around to anybody, but this presumption of innocence, even having to look at some horrific photos, Miss Nine. What do you think about that?
Let's look at them,
Yeah.
obviously, but keeping. Maintain the innocent. Difficult, but I think I'm.
Number 69. Maintain a presumption of innocence, even having to look at autopsy photos. All right, let's move along. Oh,
My line of work,
and we're gonna let you go, so don't worry. See, look at this, see how nice I am, and you're now that stress is, yeah. Yeah.
so we're told, did this.
Yeah. And you form anger towards that person because you've got a kid that's come in and hurt and that kid didn't deserve it. And it pisses you off and you want someone held accountable. Everybody feels that way. You got a kid that's hurt. Your initial instinct is I want to hold somebody accountable and somebody has got to pay a price. And that is human. But that is not the 12 people's job who's going to be on this jury, or we'll have more than that. Some will be alternate. But the people who are going to be on the jury, it's not vengeance. Even though that may be an emotion we all have to feel, we all have to put, whoever's going to be on this jury is going to have to put that emotion aside and determine whether or not they approve this case beyond a reasonable doubt for the facts or the elements like the omelet, and whether or not they prove that she was insane beyond a reasonable doubt when this happened. And so does that make Miss 28? I wouldn't want someone coming in here and say, it doesn't piss me off that an 11-year-old kid's dead. But
Separate this is two different phases.
Yeah.
The thing about what happens to the person that is found guilty, that's up to the judge, jury. It's the vengeance, that is the full weight and authority of the civil institution. Violence that the government is bringing. Consequences of whoever's found guilty.
Yeah.
We're trying to figure out if this particular person that's being put in front of us is guilty according to the rules, and doesn't mean that we don't want someone to be found guilty.
Yeah.
We have to figure out if that person is guilty. If that person's guilty, then judge throw the book out. If they're not guilty, then let's have another trial and find someone else who did do this. Matter of principle, I mean, set us apart from every other legal system on this planet. You're innocent, though we're proven guilty. Person who is guilty goes free. To prove, they're gonna screw up again. Generally. But rather, it's hard, but I would rather that innocent person not be put in prison versus a guilty person getting set free. But not, it's hard.
neither one are ideal, but that's how our system is designed. Our system is designed that it's better for a guilty person to go free than an innocent person being convicted. And no system's perfect, but that's how ours is. I'm guessing I'm running out of time here quickly. A lot of people had thoughts about not guilty by reason of insanity. Miss 21, you indicate you put on there that you think it's for cowards.
Just being honest.
Yeah, and that's all I want.
And, I just have a hard time believing.
All right, well, I mean, who thinks not guilty by reason of insanity is a BS defense? We got 62, correct? It's okay. Yeah,
Sorry, I couldn't hear you.
I think it's useful.
and would it be fair to say it'd be harder, because in this case, they have to prove beyond a reasonable doubt that she was sane. They have to disprove it. What I'm getting from you, you're not really buying that as a legal defense. It's okay. Okay. Juror number 69, you feel the same way? we already, number 47? Oh, don't worry, you're fine.
Need to wrap up.
Number 53, what do you feel about NGRI? Juror number 70, you have a degree in psychology? All right.
Say one other thing.
Yes,
Relative to, I have a little bit of a frame of reference, which is my cultural background. And when it comes to the no jury by trial and not being given an opportunity, my parents are in. So I know what happens when you come to a decision based on sanity, reasons. Because I'm not so certain that government. Decision on business. So I'm just saying, I do have that bias, which is everybody deserves their day in court. And I understand the direction of innocent. There's some.
juror number 6. No, it's good. I mean, it's good information. That's all I'm asking for, is just be honest, and thank you for being honest.
Last question.
Number 61, you indicated you don't believe in not guilty by reason of insanity. You think it's no excuse. Okay, thank you.
I wanted to follow up on a couple of things. Um, so juror 47, are you the one that said that you were not going to be here on April 21 because you're moving? Are you moving to Denver? And so remember when we started out this process this morning about are you a county resident or not?
Temporary move just for a job for like 1 year-ish period.
Okay. That was kind of what I was trying to get to. So you're planning on moving to Denver. You're going to be there about a year. Okay. All right. And then, juror number 62, I had a little bit of difficulty hearing part of your answer. Did I understand correctly that you had served on 2 juries? Well, you should play the lottery.
Yes. Yes. I have been in 2 times.
Okay, and were they on criminal were the cases criminal or civil? That would have been a criminal case. Probably a criminal case as well. Let me ask it this way. When you were on those juries, were there 6 of you or 12 of you? Okay, so they would have been criminal cases. Okay. Okay. So you've been through the process a couple of times, and I did not hear your complete answer regarding whether you can or cannot give the presumption of innocence to someone. Okay. Okay. All right. And, all right. Juror 59, you had said that you had the 21-month-old and you would be able, you'd figure it out if you needed to. Would it help? I'm sorry, juror 65. Juror 59, you probably don't have a child care issue. But juror 65, you're the one with the 21-month-old, right? Okay. And you said that you would figure it out if you had to or if you needed to. And actually, I'm right. Juror 59, you have a child care issue too. So the question that I have is, we have court care that is available in the courthouse. It's on the first floor. Juror 65, yours is 21 months old. Juror 59, your child though is coming home from school, right? Okay. So juror 65, if you were able to bring your child into the courthouse on days when you could not find care, there's some parameters that we have to work with, but it's primarily my issue, not yours, which is I got to make sure that we get you out timely because court care closes down, I think at noon. They don't reopen again until 1. So we have to make sure that regardless of where we are, I just tell the lawyers you're done for now. So that gets you out of here so you can go down. Would that be helpful?
No, and, my husband works at the Memorial Hospital and off of that a lot of times.
Okay.
But yeah, that would be.
Memorial, Maine or north? Okay, so yeah, not very far. Okay. And juror 65, or I'm sorry, juror 59, let me make sure I understand your situation. Is this going to be an issue for, I mean, if you're here 6 weeks or so, how much of a problem is this going to be for you to get your son, right? 10-year-old home? 9. Okay, all right. And juror 66, you would talk to us a little bit about your memory problems. How long have you been retired, sir? And what kind of work did you do before that?
a surveyor for a land survey company for the last 12 years before I retired.
Okay. And how are you doing with your memory today? Okay. Does it vary day by day? Or is it just over a period of time? Okay.
Over time. Come and go. Very slowly fades.
Yeah, no, I get that. My children tell me I have the same problem. It's amazing though. They say, Dad, you forgot about this. And other times they will say, are you ever going to forget about that? So, I mean, okay. All right. At this point in time, what's going to happen is we're going to take about a 15-minute recess. So I need everyone to leave the courtroom. Same thing as this morning. Remember where your seats are. We'll have you come back at 3:20. So be ready at the door at 3:20 to come back in at that point. And then what will occur is that the attorneys and I are going to have a conversation up here, and we will discuss jury selection at that point. So all rise for the jury, please. I don't care. Webinar. No, was thinking. I just don't want. Thank you. You may all be seated. Record should reflect the jurors have left the courtroom. We can do this in one of two ways. I assume Ms. Stauch would like a break at this point in time. Okay. We can do it one of two ways. We can have her take her break now and then come back and do challenges for cause. We can do challenges for cause now and then take a break. I don't know if you want to waive her presence while we do the challenges for cause. It would be my preference not, but pardon? Okay, so you just need to tell me whether you want to break right now. Okay, no, that's fine. That's fine. We'll do it now. All right. We'll be in recess then for about 10 minutes.
So did you ever see any of the Austin Powers movies? Yep. Talking to Mr.
You good to go, Kathy? Okay. Court will recall 20 CR 1358, People versus Letecia Stauch. Record should reflect the jurors are not present in the courtroom. Since they're not present in the courtroom, we can do the challenges for cause not at the bench. So prosecution, tell me everybody you want to excuse first, and then we'll go through them one by one.
Well, I think, as it relates to, we were discussing where we both agreed, 11, 21, 62, and 24. We,
Hold on, 11, 21.
11, 21, 62, and 24.
Okay,
Both sides agreed to excuse for cause.
let me see where we are. 11 is over here. 21 is there. 62 was that one back there. And 24. Okay. Oh, sorry, Mr. Tellini, do you agree?
We do.
All right, court will also excuse 11, 21, 62, and 24. 11, 21, 62, 24. All right. What other challenges does the prosecution have?
That would be the extent of it first.
Oh, you don't have any additional? Okay. Mr. Tellini?
Additionally, we would challenge 15, 9, 66, 69, um, 74.
Okay, with respect to 15, I'm going to grant that. That's the woman who has watches her grandchildren 2 days a week.
Say 15, yes.
Yeah, 1-5. And with respect to 66, I'm going to grant that based on his purported memory issues. Tell me your issue with respect to 59.
59 had some child care issues. She also, when questioned about the presumption of innocence, where it's the murder of an 11-year-old boy, said that she has significant concerns about her ability to do that.
Mr. Allen?
She also said that she could follow the presumption and felt like she could survive.
I tend to agree with Mr. Allen. I think that the way that I read her body language and everything, and I understand her child care issues, but she said she thought she would be able to figure it out. With respect to the presumption of innocence, I think what she was struggling with is what many people would struggle with, which is we have an 11-year-old that is a victim of what the attorneys have described as a violent crime. And she's juxtaposing that against the presumption of innocence. The impression that I got from her, from what she had to say, was that she could do that. It might be difficult. She might have to remind herself, but she thought that she could do that. I think that's sufficient with respect to rehabilitation to allow her to continue to serve. So that request will be denied. The next one is 69.
69 had some of the same concerns with the presumption of innocence, but also then said that she thought the insanity, not guilty by reason of insanity, was more or less a BS defense and an excuse.
Mr. Allen?
So my recollection is that 62 is the one that indicated on her
That's what I thought.
questionnaire that insanity was a BS excuse. When Mr. Flynn was talking to her 62, her 69, sort of chimed in on that, but did not adopt the same language that we've already agreed to in policy for 62. I would think that she would also be number 6 and also apply for potential rehabilitation.
Yeah, that I have the same recollection as Mr. Allen, and I'm looking at the questionnaire, and I think what juror 69 actually said on the questionnaire anyway was that she has opinions regarding insanity, and she said only if it applies, not everyone who pleads this is insane. And I don't recall any specific comments from her otherwise. And I think that's just an accurate statement of the law that, you know, sometimes it's raised as a plea when maybe it shouldn't be, but that doesn't mean that she can't follow the law in this case. So I will deny that one as well. 74.
74 had on our questionnaire. In regards to not guilty by reason of insanity, I believe anyone that hurts a child is crazy, exclamation point, but is not a reason to get off or be found not guilty.
Yeah, I remember that one. I wrote that one down too. Mr. Allen?
Trying to just check on. So, notes that, Ms. Guardiano kept on that particular, that she agrees with the presumption of innocence and could do that. Like, with that. And also, right above that, I believe I can make a fair decision based on it.
Well, I put the comments from juror 74 in a different category than I do for jurors 59, or I'm sorry, 59 and 69. I do agree that the comments, I mean, essentially what she's saying is, this is not a reason to get off or be found not guilty. There wasn't a lot in the way of questioning of juror 74. She would have been the one in the far back row, far corner. And so there was not a lot more to go on, but based on the questionnaire, I just see that as, I mean, if you look at it, let's see, 74,
I mean, she has the exclamation point.
69, no, I got the exclamation point. But if you look at the difference in tone and tenor between 74 and 69, 69 says, well, only if it applies, not everyone who pleads this is insane. And I think that's an accurate statement. But clearly I get the impression from juror 74 that she has significantly strong opinions regarding the use of a sanity plea. And it also is even much worse than juror 59, who on her questionnaire asked, you know, well, what was the history before this crime? Would that explain the plea? Is it being used to not accept responsibility? And I think that that's a logical question, and frankly, probably one that'll be at the heart of the case. So I do agree that, or I am going to grant the challenge for cause as to juror 74. So let me make sure I have everybody here.
And I just
11. Don't interrupt me for just a moment. That's all right. I just want to make sure I got the numbers in the right spot. 62, 24, 15, 66, 66, 66, 66, and 74. Okay. So you guys want to follow along with me as to who everybody should be that is excused so that we all agree on the same numbers? Or you just want to come up and look at my sheet?
No, and I was going to say 70, but she's already been kicked. So
Okay. So you want me to read the one that are excused or the ones that are still on? Because there's a lot fewer that are still on.
Probably easier to read still on.
Still, okay. All right, we still have juror 2, 7, 9, 20, 26, 28, 29, 34, 35 and 36 have been, yep, I didn't get those crossed off. 39. So the next juror that we have still on the panel after juror 34 is juror 43, 44, 45, 47, 49, 54.
Oh, I thought 47 was excused.
I don't have. Oh, whoops. Yeah, she is.
I thought it was on the yellow sticky.
You're right.
Yeah.
You're right.
Well, that was
57 was on the sticky, was on the Post-it.
47's also on there.
Did you just
But-
write down there, Will?
Yes, and I've got 7 more.
Okay,
I would,
so let's go back. We have jurors 43, 44, 45. I'm going to excuse 47 because I'm a little bit concerned. I understand how she sees residency. I'm not sure that I agree with it entirely, but certainly she's going to be gone by during part of the trial. So we have jurors 43, 44, 45, 49, 54, 56, 57. That's right. Yeah, he was the administrator. 58. Oh, there he is. So 58, 59, 61, 65, 69, and 70. Those are the people that I have as our jurors. You agree, Mr. Allen? Mr. Tellini?
I agree.
Okay, all right, let's go ahead and let him back in, Todd. Yep. You can get a copy of that if you want, if you need it at the end of the day. Kathy, you can get a copy of that if you want at the end of the day, if that'd be more helpful. Okay.
The total left.
Oh, the total left. Let's see. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. Okay. Is that what you have? Yeah. Okay.
I try to fit them all in there.
Kathy, do you need a hard copy of this?
Yeah.
Okay. Okay. We'll get you one. Yeah, but that's what I was wondering about. Yeah, that's fine. Okay. We're going to do this a little bit different than what we have done everyone else, because it is, frankly, easier to read the names of the people, or I'm sorry, not the names, the numbers of the people who will return for further jury selection on April 3. So I'm going to read those numbers. If I read your number, stay in your seat, because I'm going to have further instructions for you. And then everybody else is excused. You can go on about your business, do whatever you need to do today, those sorts of things. But the people whose numbers I read need to stay in the courtroom. So potential jurors in this case will be number 2, number 7, number 9, number 20, number 26, 27, or I'm sorry, 26, 28, 29, 34, 43, 44, 45, 49 in the back there, 54, 56, 58, 59, 61, going into the row behind that, 65, 69, and 70. So those people need to stay where they are. Everybody else is excused. If you have a question as to whether or not you're supposed to stay or not, raise your hand. You are 24, you are free to go. We'll just have them do this from their seats. Filling stuff out,
Yeah.
yeah, okay. That's fine. Okay, thank you. Okay, I have an instruction that I want to give you, and then we're going to ask for some information. You've probably already guessed that there is some public or media interest in this case. There could be more in the coming weeks. You must guard against that, as you will be required to decide this case based on the evidence presented and the instructions that I give to you. You can tell your friends and your family, significant others, people that are important to you, you can tell those people that you may be on this jury and how long you think it will go. You can ask for their help in avoiding exposure to stories or even opinions from others regarding this case. But you cannot otherwise discuss anything else about this case with anyone. And you should not listen to any opinions regarding this case from someone who is not a juror. And we'll talk about that in just a moment. If someone asks you why, just tell them it's because that's what the judge told you. That puts the burden on me and not on you. Because I know that in every case that I have, we get to a point where jurors know something about the case and know that they might be on the case. And at the end of the day, we will have testimony or evidence in some fashion. And I know when I go home, I have a lovely wife who I've been married to for more than 30 years. She's going to ask me how my day was. I will start to tell her. While my wife is a lovely wife, she also has very strong opinions. And she is happy to share those opinions with me, whether I want her to or not. So she'll ask me how my day went. I'll start to tell her. And at some point, she'll look at me and she'll say, well, you didn't really believe that, did you? And pretty soon I'm having a conversation with someone about what I should and shouldn't believe. And that person wasn't even here. You can't do that. So the way that you avoid all of that is you say, I can tell you that I might be a juror on this case. We think it's going to take 6 weeks. We believe we're going to start on April 3. The judge told me that I can't tell you anything else about it. Please help me to avoid exposure, news stories. Please help me, my friends, once they find out that I may be on this jury, may be wanting to share their opinions with me. Please help me avoid that. And tell them that the judge said that I can't talk to him about it. As I said, that puts the burden on me as opposed to you, because if I were to tell my wife, look, I'm just not going to talk to you about it anymore, it would lead to an entirely different conversation. So this avoids all of that. You can still blog or communicate with others. You can go on about your normal life. You just can't talk about this case, and you can't do any research about this case, the people involved in this case, the witnesses in this case. You can still watch TV, you can go on the internet, you can still do your Amazon shopping, all of those things, but you are not allowed to look at, read, consult, or use any material of any kind, including any newspapers, magazines, television and radio broadcasts, dictionaries, medical, scientific, technical, religious, or law books or materials, or the internet in connection with your jury service. I want to emphasize that you must not seek or receive any information about this case from the internet, which includes all social networking, Google, Wikipedia blogs, and other websites. You're not allowed to do any research of any kind about this case or this kind of case. What we're going to do, and so that you know what the process will be going forward, you've all been through this today. We're going to do this every day. Not with you, but with a different group tomorrow. We will do this every day until we reach a group of 110. Once we reach a group of 110, we will bring the first 75 back. Our hope is that we're going to do that on April 3 at 9 a.m. Couple of things. In a moment, Mr. Combs and Mr. Sproul are going to circulate around a sheet What we would like for you to do is put down your name, your juror number, not your seat number, but your juror number, an email address, and a phone number. The attorneys don't get that. Nobody gets that. That stays with us and nobody else. The reason for that is we will let you know as things progress how it's looking. It is possible that we will not have our projected number of jurors by April 3. It's possible we might have them earlier. But what I want to do is keep you advised about where we are if it turns out that we're going beyond April 3. If we have to, I don't think it's going to be that far beyond it. So we need to keep advised of that. In addition, it has our contact information on it. You should be given, they have cards, right? Yeah, okay. You have a card. We're going to be giving you a card that has our contact information on it. Has my division, my name, my phone number. We also have an email on there. And it tells you to come back on April 3. If something happens, and I've been through this before, so I know that things can change in the next 2 weeks. I don't wish that on anybody, but I know that emergencies can happen. Something can happen in your family. Maybe you can win the lottery and you decide to go to France. I don't know. But things can happen and things can change. So you need to call us and let us know. And if it's an emergency or something like that, just call us, let us know, and we will deal with it. Okay. So the reason why I'm doing this and saying that you can enlist the help and aid of your friends is because I try to learn from past mistakes. And I had a case previously where I said, you can't discuss anything about this case with anybody. And unfortunately, I received a phone call from a husband who was, he was anxious and he was upset because his wife was, I could hear her in the background crying and saying that she had to be here for 8 weeks and couldn't tell him why. So you can do that. You can explain that to your employers. You can explain that to anybody. Juror number 9, you can talk to your professors about it. If you need a letter from me, let me know. If anyone here needs a letter from me to explain to their employer what they may be doing for the next couple of months, let me know. And I can see what I can do. I can certainly get letters out. And certainly if you are selected as a juror in this case, I have no issue with providing you with those letters. So, but we need to make sure that 2 weeks from now, you are still qualified to serve as a juror in this case. The attorneys and nobody from the attorneys are going to be contacting you. Nobody from any other source should be contacting you. If that happens and it becomes a problem, let me know. And I will take steps to deal with that. But your contact information stays with us and nobody else. So that's where we are. Let's go ahead and pass that out. Oh, okay. Mr. Allen? Yes. Somebody, I think it was juror 15 who is no longer with us. She had discussed an issue about, what sort of punishment might be involved or something like that, or she would have some difficulty deciding punishment. You need to understand that if you are selected to serve as a juror in this case, you will not be deciding punishment. The only issue that you will be deciding is whether or not the prosecution has proven everything that it is required to prove in order to establish the guilt of the defendant beyond a reasonable doubt. This is not a death penalty case where the jury decides the punishment. If the defendant is found guilty, it will be my job to impose or decide the punishment that should be imposed, and only my job. So your job is really just to determine the facts of the case and whether or not the prosecution has proven beyond a reasonable doubt everything they're required to prove. So hang on to those cards. coming with us tomorrow? Are you with us tomorrow? Okay. Stop. If he needs one, tell him that. Call us and we'll send you. Got an email address, right? Yeah. He's got an email address. Just tell him that if he needs one, let us know. when we're done. We're using the gold tickets for them, right? The yellow ones. Okay. That's the other thing I was going to do. All right, I want to check on a couple of things. The first is, does everybody have a yellow ticket? Raise your hand if you do not. Okay, it looks like we got that all taken care of. Keep that with you. In addition, when you come back on April 3rd, you will come back not to the jury assembly room. So where you reported this morning, you don't have to go there. What you need to do is, it's going to sound strange, but you got to report to the hallway outside of the courtroom here. Because what will happen is, remember how we stacked y'all up out there this morning? That's what we're going to do on April 3rd. Your seats will be renumbered. You don't have to remember where you are because we're going to reshuffle you all again. But be out in the hallway, and then when it becomes time to start the questioning, or we call it voir dire, when it becomes time to do that again, we will open the doors, and Mr. Sproul and Mr. Combs will tell you what seat number you're in, and we'll go through that whole process. So just wait out there in the hallway until we're ready for you. Nobody will be bothering you, and just be patient with us. And hopefully we'll be able to do this on April 3, and we'll be able to go at that point in time. With that, remember everything that I told you. Remember those admonitions. Don't read anything about this case. Have your people help you to avoid things about this case, and push it all off on me. When your spouse, significant other, or somebody says, "Oh, I heard about that," and you can just say, "The judge said I cannot talk to you about this." And that should stop the conversation. So with that, have a really good day, and we will see you back on April 3. If you have any questions in the meantime, you can give us a call. 9 a.m. All rise for the jury, please. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. Oh, almost. There it goes. All right, record should reflect the jury has left the courtroom. Really good day by my count. It looks to me like we have about 20 potential jurors. If we have 5 more days of this, we should be done, which would put us done a little bit early. That would be a good thing. So we'll start all over again tomorrow at 8:30. Anybody have anything else, Mr. Allen?
The only question I have is, once we get to that 110,
Mm-hmm.
if we stay on the same pace, we should eventually,
Mm-hmm.
can we get the seating chart for that 110 in packets? Already have the packets, but the seating chart.
Yes.
Ahead of time.
I think so. I need to talk with Mr. Sproul about that, but I think the plan is I'm glad you brought it up because I wanted to talk about it a little bit. As I see this, it seems to me, and when I did this before, it's not a true shuffle. It is, for instance, juror number 2 is going to be juror number 1 now. And then juror number 7 would be juror number 2. So we don't reshuffle them, and then our current juror number 2 ends up as like 63 or something like that.
That's easy.
Okay, so these people, well, these 20 will be in that box.
So they'll be the presumptive.
They will be the right. Yep, that's exactly right. They will be the presumptive panel in the 20. So yeah, that's where we will be. And we'll have to talk about, as the day goes on or the week goes on, I can talk with Mr. Sproul about when we might be able to get that to you. It really just depends on how long it's going to take. I'll know, once we start getting to about 80, I'll have a better idea about how long it's going to take us. So, but
Judge, so we know, and we've already put the jurors' questionnaires that have been eliminated today in this box.
okay,
Like to keep the 20 that made it through. We'd like to keep their questionnaires just because we could be asking them questions again in the future.
not today.
Not today.
I'll think about it. I'll think about it overnight, whether you get them or not. My thought is that probably not until the end. Largely because you're not going to be asking them, you won't be able to ask them any questions until we get to that 110. And it may be once we get there, then you have all of them, and that may be appropriate. I just have to tell you, I'm very cautious about letting any of these out of my sight for lots of different reasons. But I agree that you should have access to them. The question is when you're going to get it. So let me think about it. I'm more inclined to say, wait until we get to our pool of 110 or whatever, and then you can have the questionnaires for the 110, as opposed to you need to hold on to these for the next 2 weeks.
We were
So.
going to have, I actually thought that you were going to allow us to hold on to the 20, it's actually 21, I think that we kept for today. I think the court could, to satisfy any concerns, issue a protective order regarding these additional 21 questionnaires.
Actually, as I look at what I've highlighted, I have 19. So
You have 19 ahead.
1, 2, 3, 4, 5,
You need to
6,
look-
7, 8,
You need to look at your sticky note.
10, 11, 12, 13, 14, 15, 16, 17, 18. I have 19.
2, 7,
Mhm.
9,
9,
20,
20, 26,
8,
28, 29,
34,
34,
1,
43,
45,
44. Oh,
45.
45, that's what I missed.
It's 20,
It's,
counting 47.
we missed, that's right. And so we did give, yep,
It's 20. My fault on the count.
Yep.
It is
it is 20, yep. I did not highlight one that I should have. Okay, so that's where it is. Okay, so I will think about that overnight. If we put those in, just the ones,
Okay.
if we put just the restricted ones in as sealed, only the attorneys would be able to get access to them, right?